Welcome to the midweek edition of Legal AF. This is all of the legal and political news that you can handle, and all the legal and political news that's fit to podcast. I'm Michael Popok.
And I'm Karen Friedman Agnifilo.
And Karen, we just figured it out. We're going to do 3 Gs today, ripped from the headlines. Literally, one is like from today, from Wednesday. We're going to do what happened in the Ghislaine Maxwell case. That's our first G, related to juror number 50 and her attempts to obtain a new trial. We're going to talk about poor Brittney Griner. That's our second G. She of the WNBA All-Star fan, and also, unfortunately, a person who plays in a Russian league and has been trapped in Russia now on a what it sounds like a trumped-up drug charge. And our third G is, again, right from today, the jury has come back in the Guy Reffitt, the first Jan 6 criminal trial. We have a verdict after 4 hours of deliberation, and we're going to talk about that too. But let's kick off with each other. How are you doing?
Doing all right. I appeared in federal court yesterday on a motion to dismiss. I had oral arguments, which was only my second time ever in federal court and on a civil matter. So it's all new to me, but I'm enjoying it.
Yeah. So you and I, this just again to reinforce how few talking heads really have a practice. Today, I argued at the Second Circuit Court of Appeals in person live, partially with a mask and partially without, on behalf of one of our clients, John Melendez, against Sirius XM. And the day before, I filed 2 federal briefs back to back in Nevada on another case in the gaming space. We are practitioners. We do this for a living. If I could figure out a way to do podcasting for a living, you and I have joked, I would, because it's so much better. And I like my clothes so much better on podcast day.
I know, you don't have to wear a suit.
Yeah. Or, listen, for all you know, it's just a sweater today. So here we go.
God.
Let's talk about Ghislaine Maxwell and what happened with Judge Nathan. And I want to ask you a few questions about it. First, I'll frame it, then I want to ask you questions. So juror number 50, who we've now heard about for the last 2.5 months, was on the jury, was part of the jury that convicted Ghislaine Maxwell 7 out of 8 counts, including sex trafficking, which she's looking at a lot of time for that. And then did what I guess some jurors do. They go to the media and gave a lot of interviews and signed a lot of book deals he's originally from London, so it was with some British papers. And in it, he said he was a victim of sexual abuse himself several times. And that was not disclosed at all in the jury questionnaire, which is part of the process that we've talked about in other episodes of Legal AF, the voir dire process of jury selection, which requires jurors to be honest in the answers to their questionnaire and in the answers to the questions asked by the lawyers and or the judge during the process. He was not, either because he was dishonest, lazy, as he admitted today, or something else. And the judge used her time today, and she was the only one that cross-examined him in response to the motion for new trial by the defense, to get to the bottom of why Scotty Gregg, he's identified himself by his first and middle name, why he did not disclose that he himself was a victim of child sexual abuse. Now, here's a question I have for you. It's a couple of questions. Why are the only questions she's asking of him about why he lied on the form, and not about at all? In fact, she admonished him not to speak about jury deliberations. Why doesn't she care at the new trial level when she's considering the motion if anything that he said or did in jury deliberation might have adversely impacted that process? Why do you think?
So jury deliberations have always been sacrosanct. It's this sort of this bubble that you aren't supposed to have anything intrude in that process, in the deliberation process. And so the judge was very careful not to intrude in the deliberation process of the Ghislaine Maxwell trial. But the questions ahead of time, voir dire, as you said, is all about trying to pick a fair and impartial jury of your peers who can listen to the evidence and bring in their life experiences, of course, and their common sense, and render a verdict that's consistent with the facts and the law. And in the voir dire process, it's really important that the lawyers get to know anything about you that could impede in your ability to be fair and impartial, because obviously it wouldn't be fair to the defense or the prosecution, for that matter, to have someone who can't be fair and impartial. And during this jury selection process, or this voir dire process, lawyers have a certain number of challenges. There's two kinds of challenges, and challenges mean you can say, I'm going to bump this person off the jury. You bring in panels of dozens and dozens and dozens of people. And in high profile cases, sometimes it's hundreds of people, because people will just say, I can't sit for a really long time, or I heard of this case and I can't possibly be fair. So usually in a big high profile case, they'll bring in hundreds of people and they'll pre-screen them. And they usually pre-screen them through things like jury questionnaires. And that's what happened in this particular matter. And as I said, there are two types of challenges, both for-cause challenges and preemptory challenges. And for-cause challenges, there's an unlimited number of those. It just means you can't be fair and impartial, and therefore, for cause, the judge will say, as a matter of law, you are not qualified to serve on this jury. But then there's some preemptory challenges, and the number of preemptory challenges depends on the jurisdiction you're in, on the charges you're facing, on the level of crime it is, et cetera. But in New York State, for example, you sometimes can get up to 20 preemptory challenges. Now, you can't discriminate using your preemptory challenges. So, for example, you can't say, I don't want any Black people on my jury, so I'm going to bounce all the Black people from the jury. There's things like that you can't do as a prosecutor. And there's challenges, but pretty much otherwise, your preemptory challenges are ones that you can use any way that you want, as long as it's not discriminatory. Now, the reason I bring that up in this case, and the reason I think this is significant, is the questions, just to answer circling back to your question, Popok, the questions the judge was asking juror number 50 today all had to do with his motivation, his intention, whether or not he could be fair, because she was trying to determine whether or not he would have been challenged for cause, meaning disqualified as a juror, because there's a Supreme Court case that lays out the standard. It's from 1984 that lays out the standard here on what would disrupt this and give her a new trial. And it would have to be something that goes to the heart of the fairness of the matter. It was McDonough Power versus Greenwood. It's from 1984. So if he was mistaken, though honest, the way he said he was, and the judge credits that, it might not get reversed. But if it's something that goes to the essential fairness of the trial, and if he couldn't be fair and impartial, and therefore be able to have a for-cause challenge, I think they'd be in trouble here. But my prediction, and I want to hear your thoughts, of course, my prediction is, based on what he said today, it does not get overturned. What do you think? What are your thoughts?
Let's unpack some of it. So, wow, I've never had 20 peremptory challenges. I've had 6 at most.
Have you ever tried a murder case in New York State?
No, I don't know. I'm saying that's just a lot. And even though you're not supposed to use your peremptories to remove people of color and otherwise, we know it happens, and we know that all of a sudden, maybe not from the prosecutor level, but I've certainly seen it in civil cases, where you suddenly have an all-white jury because of the use of that process. But I guess the question I asked was, Judge Nathan's not cross-examining this witness about the deliberation process, which I thought, one of the things that he said is that when he was in deliberations, he told the other jurors while they were deliberating, this is all public record now, that when there was a expert that was put on about repressed memory and the ability of a sex abuse victim to recover memories, he used his own personal experience in the room and talked about it to bolster the credibility, if you will, of the witness that was on there for the prosecution. And this does not seem to be at all the focus of what the judge is going to grant or deny the motion for new trial on. She doesn't, maybe because it's sacrosanct, maybe because she doesn't think that's where she needs to go. She's going to the Sixth Amendment right to a fair and impartial trial, not a perfect trial, but a fair and impartial trial to determine, as you said, whether, even if he disclosed that he was that he was the victim as a child of sex abuse, does that mean that sex abuse victims and sex trafficking cases can't ever be jurors? And the answer to that is no. They can be jurors if they can be fair and impartial. If they can't be, then for cause, as you said, if they say, listen, I had this traumatic thing, terrible thing happened to me, I could not sit on this jury and be fair and impartial. I'd be thinking about my own past and my own thought process. Okay, that is a for cause, which lawyers like you and I are happy about, because I don't have to use, if I have a limited number of peremptories, I don't have to use my peremptory challenges because the judge has just taken one juror off the block without me having to use it. And so that strategy and gaming that goes on between defense and prosecution, or plaintiff and defense lawyers, who's going to use the peremptory? I want to get to juror number 6, a potential juror number 6.
So true.
It's like chess. How do I get there?
You can even negotiate sometimes, right?
Oh, yeah.
You the part with your adversary, and you say, okay, I'll agree to unseating this person if you'll seat that person. Well,
you just mentioned a good thing. There's also back strikes, which means you can strike, but then you can take it back and negotiate. It's a whole, we make it sound like it's just this run of the mill, ordering like you're at the deli. It's not. It's a lot of this going back and forth, maybe less so.
I have one question for you on the challenges really quick. Do you think it would matter if the defense attorney in the Maxwell case had run out of peremptory challenges, and therefore, because I was just curious, because let's say it wouldn't have been a for-cause challenge, because he did say today under oath that he could be fair and impartial. So that knocks him out of the for-cause category. What if they had run out of challenges? And so it would have been harmless error, if you will, analysis, or moot. Like what do you think about that?
If he was up early enough that they had a peremptory, but I think they have to go the next step, which is the way you framed it, which is, we would have removed him, but removing a juror or one or two, that's not fair and impartial issues. I haven't gotten the perfect jury. You get the jury that you choose. You get the jury that's left to you after all of these challenges and this checkerboard of challenges, and the judges involved. And this is your jury. And the question is, are they fair and impartial? So they're not going to be able to argue, and I doubt that they will, that, he would have not been in there, and I would have had, the postal worker, one next to him, and that would have been better for us. That's not Sixth Amendment. So, you're right. I think at the end, if this is the focus and not on his outsized influence on jury deliberation, which it seems to be based on the questioning, I think this new trial goes down in flames as a motion, and we'll have to see what the Second Circuit does.
So you think that gets a reverse, and I think it doesn't get reversed.
No. I think the motion goes down in flames. I think it does not.
The motion goes down in flames.
It's not successful. So you and I
don't think it's successful either. So do you know who was his lawyer?
Todd Spodek, your favorite lawyer from Anna Delvey.
It seems like everything we talk about is related, right?
Yeah. Although I don't want to disappoint you, but go online and look at his picture versus the actor that played him.
I know. I checked. They look slightly different. So
Todd, I'm sure Todd's a nice person. But he should be thrilled.
I'm hoping Amal Clooney plays me.
I was going to say,
in the movie version of my life.
Todd Spodek should be thrilled by the casting in the Inventing Anna. So
I saw by the way also that the U.S. Attorney Damian Williams actually was in court today, which shows how important and significant this hearing was.
U.S. Attorney. So he's not trying the case, but he is the U.S. Attorney for the district.
Yeah. So that signals how important this matter is for the office.
And signals to the judge that this office is taking it seriously, and not to say she's not going to rule a certain way because she's got U.S. attorney sitting there, but she knows it's serious. Plus, let's be frank, she wants to get out of here and get to the Second Circuit where she's waiting to be confirmed. So let's move on to our second G. We're making great time here. Let's move on to our second G, which is going to be, after we're done with that one that you and I talked about offline that you're very interested in. So my poor Brittney Griner, who
this one captured my heart, I have to say. Go on.
12-time All-Star, She's LGBTQ. She and her wife were there, and sort of the dirty underbelly of women professional sports is that they can't make a living in the United States. The U.S. soccer team, Ben and I talked about on a prior podcast last week, just entered into a historic landmark settlement to get $22 million, which to any billionaire is a rounding error, into a fund so they can use it to equalize their pay. And here you have, and I don't really follow the WNBA that much, so I wasn't aware that if you're a star in the WNBA and your salary is capped at $200,000,
$228,000 is the cap.
LeBron James is making $48 million a year. So so 20, he wouldn't even miss if somebody took from him $200,000. He wouldn't even notice it. Okay. That's how much they're getting paid to do the same job that the men are doing, because there's not enough marketing and money in the WNBA. It's always been seen as sort of a backwater sport. So what do stars do that want to, make a living and maximize their earning potential for the talent that they have? They go to Russia. And they go to Turkey and they go to Greece, but Russia, and apparently the team that Brittney has been playing with or for the last 8 years, and bringing home the championships for them, as well as bringing home the championships for the U.S. teams that she plays for, is a team called Ikat UMM in a city near Siberia, of all places, called Yekaterinburg. So she plays for the local, and why? Who cares? Because Putin. You might have heard of Putin, everybody? Putin is really good friends with the copper and zinc mining magnate who owns that team. And he's able to lavish $1 million salaries and private apartments and chauffeurs.
Is a magnate different than an oligarch? Just curious.
Yeah, it used to be a magnate and now it's an oligarch. Magnate sounds like Thurston Howell III on Gilligan's Island.
I can't keep it track.
Right. It sounds like, a guy with an ascot, and a.
By the way, you're aging us by talking about Gilligan's Island.
I love doing that. That's what I get up in the morning saying, how can I age me? So the oligarch, a part of the kleptocracy that is Russia, is able, and they are, Brittney is the recipient of it. Why are we talking so much about Brittney Griner? Because she had the misfortune of having to return to the league after a midwinter break from New York back to Siberia, passing through Moscow, and her luggage tipped off the drug dogs at the airport in Moscow.
If you believe that story.
Well, I believe the story. I don't believe that she's a drug mule. Is it possible that she had a vape pen that had some hash in it? Maybe. I mean, or pot or marijuana. Is she carrying bundles and bales of pot through customs at the public airport in Moscow? I doubt it.
The only reason I'm just suspect of that is, January 23rd, the State Department issued a warning to United States citizens saying, don't travel to Russia, saying that U.S. citizens are going to be potentially the target of arbitrary enforcement of the law. And, I think intelligence officials have their ears on the ground and they know when stuff's going down and things are happening, and they warn people not to go. But as you said, poor Brittney, who, I didn't know anything about this before this story, but it really sort of captured my heart a few days ago. And I started kind of researching. The average WNBA salary is between $75,000 and $100,000 a year, whereas the average NBA, the men basketball teams, is $7.7 million a year. That's 10 times the amount.
That's for the guy that sits on the bench and never gets in the game.
Exactly. And the NBA owns half the WNBA. Yeah. So if they could have, yes, they may not make as much money or pack the stadiums, but if they cared and believed in pay parity, they would pay them a living wage, and they wouldn't have to travel to places like Siberia and be put in a situation where she's LGBTQ. That is not that
which is against the law in Russia.
Exactly. And to put her in that position, I'm really appalled.
Yeah.
And I hope that I hope the NBA comes out and does the right thing and starts to pay the women of the WNBA a salary. It doesn't have to be exactly the same, but something coming close to what they deserve. As you said, she's a 2-time Olympic gold medalist. She's a champion who's, I don't know anything about sports, so I can't rattle off her statistics, but she's certainly impressive.
WNBA champion, 7-time All-Star. But here's the issue. So let's say she had the vape pen in there. She had it. We know that she had to be in Russia because her league was starting up again after a winter break. The good news for our listeners and followers is that the entire rest of the WNBA who play in Russia have all been successfully extracted and removed from Russia, except for poor Brittney, who, by the way, got arrested in the middle of February, and you and I and the rest of the listeners didn't find out about it until a week ago. So this poor person has been sitting in a jail in detention for 3 weeks. I don't know what was so slow. I mean, the people around her are not doing her, unless they felt like because of the Ukraine thing, they did not want to publicize it. They must have made a strategic decision that they wanted to sort of keep her under cover of darkness.
That's what I think.
Because normally you'd be like,
yeah,
free Brittney and let's get Brittney. And here's the problem.
I know. We should reignite the free. But now that Brittney Spears has
another one
has got, but now that she is no longer under, the hostage of her father, the free Brittney hashtag, we should turn it over to Brittney Griner. And
here's the problem. The problem is that the diplomatic channels between the U.S. and Russia are non-existent at the current time, which means that probably a third party, maybe in the sports world, maybe who straddles, somebody in the NBA, somebody, some former senator, some, Russian American business person is going to have to broker a deal to get Brittney out, because otherwise, from a legal process, she's looking at 10 years. And just to give an example that, you and I hadn't heard about, but now, of course, we're hearing about it while we're talking about Brittney, a U.S. female Israeli American Jewish backpacker named Naama Issakhar in 2019 got caught with a small amount of marijuana, I don't know, a joint or two in a small regional airport in Moscow. She was sentenced to 9 years. She only got out after 9 months because they gave her maybe a commutation of her sentence, only because the president of Israel at the time, Bibi Netanyahu, was in good standing with Putin and was able to negotiate a deal, and she was able to get out after 9 months. Otherwise, she was already sentenced to 9 years. This will be and what's going to happen. Putin's going to use her as a political prisoner, Brittney,
right?
In order to use her as trade bait.
Yeah, she's a high profile hostage.
Talk about wrong place, wrong time. Our hearts go out to her.
And the thing is, she was open about struggling with mental health. Yeah. She was very open about that and very public about it. And it breaks my heart for her. And I want to send her support and love and raise awareness. I mean, look, I think you're right. I think they wanted to keep this low profile to see if they could just get her out and not have her become a pawn to negotiate, in this horrible, high stakes situation that we're in right now.
But it's 3 weeks. Now it's 3 weeks.
I know.
And she's still stuck there. But look, everybody's out. Her wife got out. And there were other WNBA players. I mean, I don't know. They were sort of in a bubble, but, LGBTQ status is not only not recognized in Russia, it is illegal in many ways. And a lot of these women are married to other WNBA players or other same-sex people. And I'm glad we got them out. But now we got to put a lot of effort on Brittney, and you and I will continue to follow that story as we move to our third and last G for the midweek edition of Legal AF. Guy Reffitt, who Ben and I picked it up with our Saturday podcast talking about the first Jan 6 trial. For those that are asking, what is the Justice Department doing? They're doing lots of things, but one of the things they're doing is they're trying to try 500 people for participation at the Jan 6th insurrection. And so Guy Reffitt, and now I know why, we'll talk about at the end. I saw the press conference with his wife. I guess you can call it a press conference. I now know why he went to trial. I asked Ben, why this idiot would go to trial with so much evidence against him? Because he wants to be a martyr. Because they call themselves, I don't know if you caught this, they call themselves the 1-6ers. like the 76ers. They're the 1 Sixers, which is, again, too smart.
For January 6th?
Yeah, of course. Yes, the 1 Sixers.
Okay,
So now they're in a cute club that they get to say, So at the we'll talk about the conviction today after 4 hours of deliberation, but we'll go first to the wife on the courthouse steps who sent out a signal to all the other 1 Sixers and said, "Don't take a plea. We need to band together. We were only expressing our First Amendment right. Your First Amendment right to use a fire extinguisher on a Capitol Police officer. Your First Amendment right to use bear spray to cause a heart attack of one of the Capitol Police. That to go and try to find Nancy Pelosi and drag her out by the roots of her hair. That's your First Amendment right. I mean, they are still nuts. And if he doesn't come around in the June sentencing, and he maintains this position of not showing any remorse.
Yeah. The judge is going to slam him and give him the max.
Even though it's a Trump appointee, I looked her up, Dabney Friedrich. She's a former U.S. attorney, assistant U.S. attorney. She was on the Sentencing Commission. She's got a good track record. She throws the book at him. So let's talk about what happened. So what happened today with the with the counts and the jury deliberation, Karen?
Yeah. So, it was really quick. I didn't understand the defense strategy. It was a short opening.
I'm sorry. You're suggesting there was a defense strategy.
I mean, I've just never seen anything like it. There was like a 10-minute opening statement. They didn't put on any witnesses.
No, three
It was
minutes.
a 3-minute opening statement.
Yes.
Oh my God.
Yeah.
Well,
it takes longer to make an egg.
Yeah, exactly. So I don't know. I don't really understand what, and not only that. So say you want to be a martyr and that you want to make a statement and exercise your First Amendment rights. How cruel of a person can you be to put your own son through that, to make him testify against his own father? To me, he's a sick person who has, and now that you tell me, I didn't see the press conference, that his wife stood by him. So the mother is also like, this family put your family first. Do not put anything else first. I mean, these people are delusional. I can't believe it. But anyway, getting to your.
So wait, before you go on the kids, I want to ask you a question. So I'm going to give you one fact point. And then I want to hear from the former prosecutor that you are, what you think. They put on the son and he did really well. And while that son was testifying at the very beginning, in the open courtroom with the jury present, Guy Reffitt burst into tears and turned red-faced and sobbed during much of his testimony. The prosecutors, at the end, decided not to put the daughter on. Why do you think that is?
Because they have a heart, because the prosecution has a heart, and they got what they needed out of the son, right. And don't ruin this family even more. First of all, this is one of 100 potential trials. They have a long road ahead of them. They have a conscience, and they're just not going to, there's no reason to put her on and put her through that. It's got to be, this son he's 19 years old. He's going to be marred for life, just having to testify against your own father and then watch your father sit there sobbing. And the reason he was sobbing, I'm sure, was because he was disappointed, not because he felt bad, not because he has any regrets, but because he was disappointed. This is me just totally guessing, by the way. I have no,
that's what we do here on Legal.
I know, but he just that he's so disappointed that his son is clearly sees the insurrection for what it was and is willing to come forward and do the right thing and testify against your own parent. I mean, I think that's just got to be the hardest thing. And I used to be a child abuse prosecutor. And so I know what it's like for these children, and he's not an abuse victim in the sense of a typical child abuse. Although I think threatening your child with a gun, if he comes forward, is child abuse.
I'm sure it wasn't the first time in that household.
Yeah, well, exactly. It's a very tough thing for psychologically for a child to testify against their father. And, it takes a lot of strength and a lot of courage. And I applaud that child and really think I admire him for the courage and strength that he had, that not a lot of people, not everybody has. And, it's a hard thing to do.
I like your observation about the prosecution having a heart and also keeping something in the tank, because they've got like 400 more of these. Although
And clearly they didn't need it since what it was a 3-hour deliberation or 4-hour deliberation.
4
So
hours.
clearly, so they didn't need the daughter. They had a good read on their case.
Yeah. So I think there's another reason they didn't do it. They have a heart. I also think they were worried. This is just my seasoned speculation, that they didn't want to also engender any sympathy with him, bursting into tears again. They knew they were up on points by a large margin the way the trial was going. They didn't need the overkill or having it backfire and him screaming out, "Honey, I love you," or something from a movie.
Yeah, I agree with you. I agree with you. I think that's a good point. Yeah,
right?
No, I agree with you.
So let the daughter go. And plus the mother, I'm sure, was not happy, as you can see from the press conference, with the daughter testifying, and I'm sure made the prosecutor's life a living hell in that way. And the old joke.
Plus, the daughter was a minor, right?
Yeah, the daughter was a minor.
And the son was not. So he can make his own decision.
That's right. And I think the mother influenced it. And we're piecing it all together here. The thing that I loved about the 4-hour deliberation is it proves the old adage that I've seen in my own career, which is juries never reach a verdict, even if they're going to do it quickly, before lunch. The 4-hour
want the
mark,
free lunch, right?
The 4-hour mark is 3-4 hours is the earliest I've ever seen it, and it's after the bailiff has delivered lunch. Because they get charged, right? And the charging takes so long. The reading of and we'll talk about this on other legal AF midweeks. The charging, the jury instructions that the judge gives can go on for like an hour, and they are like watching, paint dry. And even for lawyers, I've almost nodded off during, and they're important because if they get a word
they're really
wrong,
important. Yeah.
Yeah. If they get a word wrong, you get a reversible error from the instruction. So by the time the jury's instructed, by the time they grab their pads and the bailiff takes them back to the deliberation room and reads them the riot act about what they can and can't do, I don't even know when it ended. It's getting close to lunch. They bring the sandwiches. Everybody orders off a menu. This is the insider stuff that people come to Legal AF for, by the way. They get the tuna salad and they get the ham sandwich. And then they eat their sandwiches and they take a quick straw poll.
And then they come out. Yeah.
And then they come back 20 minutes later and say, it's not really 4 hours. It's lunch plus 20 minutes of deliberation.
I mean, look, I've seen a 17-minute verdict. Very rare, but I've seen 17.
That was in the morning.
I've also seen my husband had a jury out for 6 weeks once. I mean, it was unbelievable. And then
how many Allen charges were they?
Oh my God.
How many charges were they given to continue to deliberate?
I don't recall, but it was 6 weeks. He actually missed our family vacation because we thought for sure, and I went and I said, "Oh, you'll come meet us." And he never was able to meet us. But the Maxwell, the jury was out for 5 days. And I think, a day, 2 days is common. So
I've seen I've handled trials where, it's between 1 and 3 days. I don't think I've ever gone to 5.
No, but three
or 3 hours. I've had 3 hours.
Exactly. I just wanted to give the context that 3 hours is considered a really quick verdict in the world of prosecution.
I also didn't hear, maybe because it happened so quickly, I didn't hear that they sent out any notes at all to the. Well, look, when you have it, I'm not kidding. When you have a 3-minute egg timer for your defense opening, I mean, even the prosecutor was only half an hour. Given the volume of evidence, didn't you think a half an hour was sort of short too? I just think they had so much that they were like, we're going to do it in half an hour. He did it in 3 minutes.
You could have literally a 5-second gunpoint robbery, right? Someone comes up to you in a dark alley, points a gun at you, takes your wallet and runs. Right. The whole thing happens in 5 seconds.
2-hour opening.
I was going to say that's an hour opening statement for a 5-second crime. This is, I mean,
Karen, it takes me an hour to clear my throat.
It's just interesting to me, just to see this. And but
what you make, I want to leave it on this. What from a former prosecutor standpoint, what you make of the defense lawyer in his closing? I think that lasted 4 minutes, but in his closing, he conceded that his client committed a crime. It was just a misdemeanor, and that everything else was puffery and bragging, and he didn't really do anything, and no one testified that he punched anybody, and let my client free. What do you think about the admitting of the misdemeanor crime?
I think that's a tactic that is used and is successfully used very often by defense attorneys. However, not for only you got to do more than 4 minutes. I mean, if that is your theory and you want to say that it's a misdemeanor, not a felony, misdemeanor being the exposure will be obviously less than a year incarcerated, whereas he's facing 20 years on this felony. So there's a reason why you would argue that, because he's on tape, he's on videos. You said that he had a GoPro camera where he's showing all of it. So there was no doubt he was there. So I think that was probably the only defense that he was there, but he didn't mean it. And it was it was all, over exaggerated, and it's a misdemeanor. But then you have to methodically not only break down the government's theory, but put something on yourself as to why it's a misdemeanor and not a felony. You can't do that in 4 minutes. That's a 4-hour summation right there.
Maybe he was double parked. Maybe he had to get out of the courtroom. I don't know, but these are the types of things that you and I like talking. This is the inside baseball stuff, even though you told me earlier that you're not a sports person. It's the inside molecular level things that people come to expect from Legal AF Law School podcasts, midweek editions. And we've just delivered another one. And we're at the end of this show. I really appreciate the listeners and followers. Shout out to the Midas Mighty. Always, as I've said before, and I mean it, I can't think of a better Wednesday night way to spend it than with Karen, Friedman, Agnifilo.
I hope YouTube lets us on this time.
We're out of YouTube jail. That's right. We should end it on that. We are officially out of YouTube jail. And it wasn't even us. It was our brothers at Midas Touch, who did nothing wrong, by the way. And they got, I think the Midas brothers actually posted it. They got a form tweet back that said from YouTube, "Sorry, you're totally right. That was not consistent with our policies. Oops." And I'm like, wait a minute. You and I had this amazing podcast last week, and then we had a scramble with 2,000 of our closest listeners and followers and go find another outlet off of YouTube. And by the way, we had our highest watched, listened to, downloaded episode of Midweek Edition since we started. Wow. I think we should create a stampede effect every show with some sort of, we're in jail, everybody, let us out, go meet us on Facebook. But this one we're dropping on YouTube. It will be shown on time this evening, and then in all the other places that people get their podcasts. So thank you again. We'll see you, Karen, next Wednesday, and I'm sure we're going to have a lot to talk about.
Great to see you, Popok.
You too. Bye.
Bye.